If you pick up a fourth case, holy moly, I'm going to absolutely lose it. Do you understand? I want my community safe. When you're out there, you need to make the right decisions before you do something. Think, if I do this, what's going to happen? If I say this, what's going to happen? And if it could lead to a bad result, then don't do it. Do you understand? Can you run his license to see, does he have a valid Your Honor? Okay. You're not allowed to drive unless you have liability insurance as well. Do you understand? If you don't have car insurance, you cannot drive as well at all until you have a license and car insurance. Do you understand? Okay.
In this opening segment, Judge Fleischer gets visibly frustrated with a repeat offender who keeps picking up new charges. The judge makes it clear that his number one priority is community safety, saying if the defendant picks up a fourth case, he's going to lose it. He warns the defendant about driving without a valid license and insurance, and stresses that every action has consequences. This clip highlights accountability, tough love, and the idea that poor decisions today can destroy your future tomorrow.
Do we have any conditions, on the terroristic threat?
Judge, I got assigned to him, he's already back.
Correct.
So I don't know if there was anything with the previous case. I know one of them is against the brother. My understanding, I think
so. I guess tell me about it, Alex, please, on both terroristic threats. Who are they?
Terroristic threats? Yes, Judge. So on the first terroristic threat, the complainant and the defendant are brothers. Dispatched to a residence in regard to a family disturbance. The defendant was removing the complainant's belongings from the residence and putting them in the back of his own vehicle to prevent the complainant from getting his things. The complainant tried to remove his things from the vehicle, and the defendant stated, "I will kill you." The complainant was in fear for his life when the defendant said this, and the defendant also later texted the complainant that if he touched his things again, he would cause him severe pain.
This is the second one.
And the second terroristic threat occurred on October 26, 2024, when the officer was dispatched to a Crunch Fitness. The officer made contact with the complainant, a manager at the gym, who stated the defendant was involved in verbal and physical altercations with other members of the gym, and multiple complaints were filed. The complainant stated the defendant's membership was canceled due to issues with other members and the defendant making threats. The defendant then continued to act aggressively after finding out this information and caused a disturbance by screaming and cursing loudly. The complainant told the defendant he needed to leave and not return. The defendant became more agitated, left the business, returned multiple times, and when the complainant stepped out with the defendant and told the defendant not to return, the defendant responded multiple times he was going to come back to the business and kill the complainant.
Okay, Judge, I would argue on that one. I'm going to come back. I don't see an immediate threat or anything like that, any brandishing of anything.
You're right. It's the going to that.
They say, repeat what the threat was again.
He responded multiple times he was going to come back to the business and kill the complainant.
I'm gonna come back, I think that there's enough to go forward. Don't go back to these places. I don't want you to have contact with either of the complaining witnesses. Do you understand? I'm going to have you sign these bond conditions. Make better decisions when you're out there, Mr. Jenkins. At some point, someone is going to stop bonding you out, and you will be stuck like Chuck in there until these things are over with, and it's going to be a long time. Do you understand? You've asked me to give you a different lawyer. This isn't Burger King where you get your way. I will not give you another one. If you're unable to get along with Mr. Perez, then probably not him. Do you understand?
Yes, I do.
He may tell you things just because you don't like it. It doesn't give you a cause to complain and I don't like this person. No, he's going to give it to you. I've worked with him for many, many years. I trust him. He does a good job. That's why we gave him to you. You understand? Okay. So we'll have you sign these bond conditions, and after that, you'll be free to go. So he was not, I guess, having a good time with the prior lawyer.
Sure.
So
I spoke with his mom already over the weekend.
okay.
We had a really good talk about what was going on. I didn't know if she was going to bond him out as soon as she did. So we're about to go have a talk to the factory.
My guess is, though, is that if it's mom, she's not going to continue to do it, because every time she bonds you out, all you're doing is you're giving free money to bonding companies. When you pick up new cases, all you're doing is you're giving money away. And I'm sure your mom doesn't have unlimited funds to just keep putting money away. Get a clue. What do you do for a living?
I worked for Uber because the job I was doing.
No, I just want to know, are you fully employed?
No, not at the moment.
You need to get a job. You have too much time on your hands and you become self-destructive.
It's hard to get a job because of my resume.
Did she tell you something? Do you think it gets easier in life? No. You don't even have convictions. and it's hard for you to find a job. How hard do you think it's going to be if they end up in convictions? Do you see my point?
Sure.
Make better decisions. 95% people are in there because no self-control. All right, Matt.
This part focuses on two terroristic threat cases, one involving a family dispute, and another at Crunch Fitness, where the defendant allegedly threatened to kill a gym manager. The judge finds enough evidence to move forward and strictly orders no contact with the victims. Then comes a powerful courtroom moment. When the defendant asks for a new lawyer, the judge shuts it down, saying, "This isn't Burger King. You don't get it your way." The message here is clear. The court system is not a game, and repeated bad behavior will eventually leave you stuck like Chuck in jail.
Is there previous conditions from?
Yeah, I will just have them sign those.
Okay.
Yeah. So Matt, these are state's bond conditions, so they've already been filed. All you need to just sign. Mr. Hernandez, you're charged with evading arrest or detention. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 19, 2025, at approximately 11:17 p.m., the officer was dispatched to a discharge of a firearm call on Tilbury Woods Lane. Multiple calls stated there were multiple gunshots in the area, and while servicing the area, the officers were flagged down by a citizen who stated she heard multiple gunshots and a green sedan sped off. Multiple citizens provided video footage, and the officer saw a vehicle that matches the description parked illegally in front of a residence on Moss Springs Court Road, and multiple males exited the vehicle. The officer then initiated a traffic stop, and the driver and passengers began evading on foot. Officer ran after all three males for 100 yards, and all were detained by the officer. The defendant and others admitted they saw emergency equipment and decided to evade on foot. Surveillance video showed the defendant throwing an AR pistol with no serial number in front of the residence, and surveillance video matched the defendant's clothing.
You're saying our defendant here was seen throwing an AR?
Allow me to read the DM to confirm that it is.
Sure. They filed a tampering. Am I right in assuming that that's the serial number?
Yes, Judge, it is this defendant throwing the AR, and the firearm had no serial number. Yes.
How can you impute the tampering because it's a specific intent crime, right? Unless you have an admission or something like that. Something that happened. But you know what? That's not even my forte. It's like we're doing the evading right here. So
fighting upstairs, gonna
I
fight
gotcha.
down here too. So you can already expect my issues with this case already.
you know, you're 17, you're now starting your life. This is not a good way to start. You know, you only have two ways that you can go. You can go up or you can go down. Life doesn't get easier the older you get. It only gets more difficult. You get bigger, fatter, you lose hair. It doesn't get easier. And it starts with school. Stay in school. Don't hang with dogs. You're going to get fleas. Do you understand? Mr. Hernandez, you are not to smoke weed. You're not to use alcohol. And I'm making that a condition of your bond. I don't want you to have any possession of any weapons as well. Do you understand? If I find that you're in possession of a weapon, I'm going to revoke your bond. I'm going to put you in jail. You're going to finish school with me. You understand? Did they impose any other kind of restrictions up there as far as like curfew or anything like that?
They did not. At first, he had an ankle monitor with the curfew. I asked the court. They agreed to take it off. So his mother and him are going to go after this court proceeding to get that removed.
Is mom here?
Mom is here outside with his younger sister.
Okay. Make good decisions, man. Once you start racking up convictions, I'm telling you, it's over. It's not going to get easier. You understand? We've given you a lawyer. It is your responsibility to stay in touch with her. She's great. She will help you out. If you're not listening to her, you take off. I can't find you. You pick up a new case. I'm going to put you in jail. No more PR bonds for you. Do you understand? One more thing. I will test you in about 45 to 50 days. And if I find that you're smoking weed, it's not going to go well for you. Do you understand? You will get tested. Be ready. So I don't care what you're doing. If you stop doing anything that you shouldn't be doing now, then you should be fined in 45 to 50 days. But if you continue to use, or if you smoke, it's not going to go well. You understand? Okay.
Thank you.
Thank you so much for coming. We got you. And then anything you need, whatever you need, just come back and we're happy to help.
Thank you, Judge. And just one thing real quick with Kate. I know there's other people that were in this vehicle allegedly. Do you have any names for them? Can you,
I can see.
if I circle back around from you?
Oh, co-defendants? That's a good, because you know what?
Well, that's part of my issue with both of these cases.
And Your Honor, it does not appear there's any connected cases.
So I have,
So
yeah, that's my issue with the tampering. That's my issue with this case.
They got them all, right?
That's what they say.
Maybe just because of the surveillance shows allegedly one being thrown and that's why they only went after. Perhaps, I don't know. But
I won't fight everybody too crazy today, but probably the next day. Yeah.
well, I'm with you. You know, whatever you need, just
Thank you, guys.
make good decisions. That's all we're asking you to do. All right? Okay,
you very
guys.
much.
Thanks. You got it.
I have
Mr.
a
Venegas.
question for the respected audience here again. When a teenager is already facing weapons, evading, and substance restrictions, is this intervention early enough or already dangerously late?
Yes. Mr. Venegas, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. I have previously found probable cause on this case. I'm ordering you now as a condition of your bond not to participate in like-kind activity. If I find that you're racing, reckless driving, acting a fool on the highway, number one, I'm going to revoke your bond, put you in jail. The second thing is I'm going to take away your privilege to drive. Do you understand?
Yes, Your Honor.
Do you see if he has a license?
still running it, Your Honor. For some reason, slow.
Mr. Venegas, you are not allowed to drive unless you have a valid Texas driver license and liability insurance. That is also a part of your bond conditions. If I catch you driving and you don't have a license or you don't have insurance, it's not going to go well for you here. Do you understand?
Your Honor.
Okay. You have a lawyer. It is your responsibility to stay in touch with him and he'll tell you when you have to come back. If he tells me he can't get a hold of you, then I'm going to issue for a warrant for your arrest. You pick up a new case, act a fool in the free world. I'm going to take it away.
I'm able to run it right now, Your Honor. It's not letting me on our system.
So can you follow the same conditions on the racing that we did?
Same racing conditions. Yes, Judge.
All right. So I'm going to have you sign a reset. After that, we'll have you take a seat in the jury box while we'll get your bond conditions. You have to sign it. And after that, you'll be free to go.
Good morning, Your Honor. Wanted to approach on behalf of Chaston Blackburn regarding probable cause. I have an issue with probable cause in this case, Your Honor.
Okay. Let's do it.
So officers were conducting an unrelated fatal accident investigation when they observed the defendant's vehicle traveling at a high rate of speed towards the blocked portion of the roadway. The officers saw the defendant disregard a barricade and were able to successfully get the defendant to stop by shouting verbal commands and utilizing their flashlights. Upon contact, the officers observed a moderate odor of alcoholic beverage, glassy eyes, watery bloodshot eyes, and slurred speech. The defendant admitted to having 3 drinks at a nearby bar and was temporarily detained. Standard filtered write-ins were conducted. HGN 4 out of 6, walk-in print 4 out of 8, one leg stand 2 out of 4. DICs were read and the defendant consented to breath. The results were .086 and .084.
This clip shifts to a 17-year-old charged with evading arrest and allegedly throwing an AR-style pistol with no serial number. The judge questions the tampering charge, but still delivers a serious life lecture. He tells the teen that life only gets harder and warns him about drugs, weapons, and violating bond conditions. The emotional hook here is intervention versus consequences. This is a young person at a crossroads, and the judge makes it clear that one more mistake could mean jail time and a permanent criminal record.
Your Honor, when you turn on the video and it's between,
But remember, this is probable cause. I don't get access to all that stuff.
I understand that, Your Honor, but when the officer basically decided that he's going to arrest her, basically he puts her in the vehicle, and before any investigation is done, he says, I'm charging her. This is prior to basically any field sobriety test being done. She didn't have any slurred speech, Your Honor. No bloodshot red eyes at all. He said all the buzzwords to trigger probable cause. I'm asking the court to watch the video for 5 minutes, Your Honor.
No. That's in for a suppression hearing. This is a mere probable cause, right? So because I have to give them the ability to respond to your arguments. We can't do that in a probable cause. Like, you know what I mean? So if you're saying it is as it is, see if they'll do a dispositive motion to suppress, where if you win, they'll dismiss, but if you lose, you got to plead, right? Otherwise we can set it. But when you start getting into the video, when you start getting into the minutia of, well, she really didn't have this, she really didn't have that. I have to give them the ability to respond to that. I can't just rule on it, whether, there was an actual traffic infraction, that's like probable cause or not, right? But when you start getting into the actual details, everything, I mean, that's for, either a suppression or for trial.
That's fair.
So ask them if they're good for, dispositive. That's something that you want to do. Let me see. It's only 60 days old, so you've got some time, I'm happy to do however, go forward with however you want to go forward, but for probable cause purposes, you're getting into argument, right? And I can't give them, I have to give them the ability to respond, Okay, sorry. Okay. Hey, what's up? Hey,
Hey,
how are you?
I'm here with Miss Belen Ibarra.
The last
Ibarra.
Ibarra. Okay. What's the word?
So, this first for bond, she has a bond set in this case because she was on no bond for the felonies last time we were here. But the state is unopposed to a PR bond in this case because
She's being held at no bond. I'm upstairs.
I know, and the felony attorney is working on that. They resolved the felonies on Friday, and the bond was not relitigated up there.
She's going into a PTI. She's going into like a 1-year PTI upstairs. And as part of that deal, we're going to get rid of our misdemeanor, but obviously she needs to get out in order to get into the PTI and everything.
The felony attorney knows about the bond issue. I don't know when she plans to address it, but I'm just here to get her out on the misdemeanor.
Right. Since it's going to be dismissed one way or the other with felony PTI. So I just want to make sure that our case isn't holding up the felony offer essentially.
Is she here now? Do we have her?
She's in the holding cell.
Do you mind bringing her out? I mean, they don't even have a date set upstairs, though.
That's
I
set for
know.
126.
I've spoken to the felony attorney. It was a misstep on her part for sure, but I spoke to the felony attorney and she will go approach on it at some point. I mean,
Are you anticipating a PR bond upstairs, too?
I would assume so, yes, because she has a PTI, like the felonies have been resolved, so I would assume,
Never
yes.
assume anything,
I know.
you know?
I know, and I can't speak for what happens in the felonies. I'm only on the misdemeanor, Your Honor, but
And I just see that the agreement's it's in deeds and everything. So
Yeah.
it looks like we're moving towards that.
yeah,
I just want to make sure that we don't.
When do you want to set it for? Do maybe like a week,
yeah, that's fine.
and we'll see? Okay.
That's fine.
Does she have history of like flight? Do you know? Because she's got
She
two.
has no history of flight. She lived in Houston most of her life. She is pregnant right now. She's 6 months pregnant, and essentially, we just kind of want to
She has
get her
two
out.
prior assault cases. Both of those, any flight in respect to those cases?
I'm not sure. I actually ran over here.
I don't think so. Based on what district clerk shows, no, Your Honor.
Let's take a look. I don't see.
All right, go ahead and
So she only has one prior assault. It looks like that one was dismissed. And
Yeah.
this new one here, looks like it was charged assault of a hospital personnel, right?
Yeah, that got dismissed on Friday.
Did they refile it as? Okay.
It just got plain dismissed, and then the PTI is for the assault on a public servant, I think. It's a mental health case, Your Honor.
I'm down with you. I'll grant you a PR bond.
Okay, thank you.
The only thing I'm going to ask is that she stays in touch with you, right?
Yes.
I'm not going to continue to do this. Like if she gets out, she just takes off. I'm not going to do it again,
Yeah. Yes,
and I'll
I
admonish her
understand.
as such. So
Thank you, Your Honor. I guess she'll still come out, right?
yeah, I need to admonish her.
Yeah.
Who is our CW?
CW.
Hold on a second. We'll get there.
Yeah.
Hold
That's right.
on. Tell me what you got.
I have Sarah Castillo, Judge.
Okay.
That's the one where we were trying to get the records from the sheriff's office. They finally got them to me. And
You have everything you want?
I haven't been able to get through it all. It's like almost 600 pages.
Second. Okay. And that is going to be long. Okay. Gator. Blossom. Do you speak English, ma'am?
Yes, sir. Yes, Your Honor.
You see, Barry, I want you to understand and appreciate that you have a lot of lawyers that are going to bat for you now, trying to help you even get out. Your lawyer here is asking for a PR bond. You even have the state that's in agreement to get you a PR bond. The only thing that we're asking you to do is be safe to our community. Don't pick up any new cases and stay in contact with your lawyer. Right now, I'm going to grant you a PR bond, but I'm not going to do this over and over and over and over and over. I'm going to give you one chance to get out there and do the right thing, make the best of the chance that you're giving. But if you get out there and you just take off and you don't stay in contact with anyone and you pick up a new case, all bets off. Do you understand?
Yes, Your Honor.
I'm not asking for much. All I want is my community to be safe and for you to stay in contact with counsel. That's it.
The final segment covers multiple defendants. One charge of racing on a highway, another with DWI after blowing over 0.08, and a pregnant defendant seeking a PR bond while entering PTI. The judge carefully balances fairness with strict conditions. No racing, no alcohol, stay in contact with lawyers, and no new cases. The consistent theme across all cases is this. The court is giving chances, but those chances are limited. If defendants continue to act reckless, the bond will be revoked and jail time becomes reality.
Understand?
Yes, Your Honor. Thanks.
Judge, I just had a quick question. We're set for trial tomorrow in ERD on a family violence case. And I just wanted to know logistics wise, would we pick tomorrow and then start Wednesday? Or if we have a jury tomorrow,
Are you really going to go?
I mean, it sounds like we're gonna go.
You hear this? I've got 7 other cases set for trial as well tomorrow in here.
Okay.
So let's see which one actually
Yeah, let's
goes.
see what the trial
So, but technically we pick on a Tuesday, everything starts testimony on a Wednesday, and then we go.
Okay.
That's the way. So, yes, thank you. Mr. Arsenault, you are charged with interference with the emergency request for assistance. You are facing up to a year in jail and or a $4,000 fine. It seems that probable cause has already been found in this case.
Yes, sir, Judge. I don't know why we're here.
Because he bonded out.
Oh, yes,
He's been, I guess he's been AWOL, right?
No, sir, he's been in custody, Judge. He had a felony assault of a family member that was dismissed last week,
Okay.
and that's why he got out.
All right. So are there any kind of bond conditions that you guys would like to see?
So for this one, just standard condition would be fine with this type of case. And there's no contact for this.
Who's the complaining witness in the
His mother.
His mother, Judge.
okay. Is that the complaining witness that was in the felony as well?
That's correct, Your Honor.
Okay. So I'm ordering you not to have contact with this person. Do you understand?
Judge, if I may, I provided the state with some information relative to that. The complaining witness in this case is not willing to go forward. She provided a letter to me, which I have already given to the state. She's requesting that the case be dismissed.
The state would not be opposed to no threatening or harassing contact at this time. And just give us another date to reset to look at the 911 phone calls to make sure that.
Okay. So the case is 180 days old. It's time. So we'll give
Okay.
you a week.
Yes, Judge.
So I'm ordering you not to have any threatening or harassing contact with the complaining witness in this case and not to be in possession of weapons. If I find that you violate these conditions, I'm going to revoke your bond, put you in jail. Do you understand? I'm not asking for much. Now your case is old. It's time to figure out what we're going to do. So I'm going to give the state a week to get everything done, wrapped up. They're going to put an offer on the case. The next time we come back, you must either accept the offer or I'm going to set your case for trial. Do you understand?
Yes, sir.
Okay. So do you mind filing those conditions, please?
Yes, Judge.
All right. We're going to have you sign the conditions. After that, we'll see you in a week. We'll go from
Thank
there.
you, Your Honor.
Okay. Thank you, Mr. D.